There is a major step in the case against Charlie Kirk's alleged assassin, Tyler Robinson. A week-long evidentiary hearing will start tomorrow. Now, Kirk was murdered while speaking at one of his Prove Me Wrong debate events. That was last September. After a 33-hour manhunt, Tyler Robinson turned himself in. He faces multiple charges in the killing, but to this day, he has not entered a plea. This week in court will be big. For one, Erica Kirk, Charlie's widow, and his parents will be traveling to Utah to sit through this hearing. And at the end of this week, we will know if this is going to trial. It all hangs on one man, and that's the judge, who will determine if there is enough evidence for the case to proceed. Among that evidence, text messages between Robinson and his roommate and romantic partner, Lance Twiggs, who also goes by the name Luna. In one of them, Robinson says he was the one to kill Charlie Kirk. There's also a handwritten letter to Luna where Robinson says, quote, "I had the opportunity to take out Charlie Kirk, and I took it." And an ATF report that was unable to identify the bullet recovered at the autopsy to the rifle allegedly tied to Mr. Robinson. Now, whether that bullet came from the alleged assassin's gun, well, that's still inconclusive. Earlier tonight, I spoke with attorney Mark Reichel about what we might see in court this week. Here's a part of our conversation.
All right, let's dive in here. I want to start with probable cause because this is, of course, different than the beyond a reasonable doubt standard we typically talk about in court proceedings. What's the difference between the two? How much do prosecutors have to present to the judge here?
Really not a whole lot, although they still want to have a strong case, but it's much different. I tell my clients all the time, a preliminary hearing, the judge has to find only two things. One, a crime was committed, and two, somebody sitting in the courtroom, the defendant, is the one who committed it, and it's by almost a scintilla of evidence. Probable cause just what a reasonable person would then suspect is accurate. So it's the lowest standard we have. We set it that way so we don't have two trials. We want to have one in advance to screen things out, make sure we at least have the right person, and we can prove a crime was committed. It's just a scintilla of evidence for the judge to find it's likely that a crime was committed.
We know the hearing is expected to last all week. What can we expect as we follow it all week long?
They don't. The prosecution's not going to want to leave anything out. They're not going to, keep going and piling it on. But they are going to put on DNA evidence, okay? And they're going to link the rifle trigger to this individual. Number one, the trigger on the rifle, okay? They're going to link his DNA, not just fingerprints, but I believe DNA, okay, to the cartridges that were spent that were found nearby. And then they're going to have, of course, the confession note. They're going to have that. And with all of that, it's going to be really difficult for the defense to try to find some hole to poke through and beat a prelim. That's not going to happen. They're going to get a holding order, bounding it over for trial.
Prosecutors say they plan on bringing in police officers as well to testify about the case. What might their testimony look like, Mark?
They're allowed to testify to hearsay at prelims. It's not like a trial. We have the right to confront your accuser, make sure they're in the courtroom. In a prelim, one level of hearsay is allowed, which means an officer can testify. He heard from someone else as follows, and will testify. They'll read from reports. They'll give, they'll give a comprehensive view for the judge of all of the outline of the case, and some of it will involve hearsay, things they didn't see with their own eyes, but other officers saw, observed, and gave them.
What about a recorded statement that's expected from Robinson's roommate and romantic partner that's expected to be played during the hearing? This, who I mentioned, is the one who Robinson exchanged texts with. He wrote a letter to, allegedly confessed to committing the crime. Do you believe that alone will be enough to warrant a trial?
Probably not. That's not enough. They're going to have every statement that comes in. There has to be something to corroborate it, because we can have people make things up all the time. So there has to be some physical evidence that corroborates any statement that comes in. But this is going to come in. His defense attorney said, "We don't want the recording in, Your Honor. We want to cross-examine that person in the courtroom." And the judge said, "Your day for that under the Constitution is at a trial, not at a prelim. At a prelim, hearsay can come in. So they don't need to bring in this romantic partner. They can just bring in the recording of that statement."
So knowing it's a prelim, will we hear from Tyler Robinson at all this week?
No, I've in 37 years, I've probably had two clients take the stand at a prelim. So no, okay. It's only if you think you have a chance or a shot at getting out.
I mentioned this earlier. Robinson has not entered a plea to any of his charges. He will enter a plea if the judge pushes forward with a trial. He's already allegedly, like we talked about a second ago, confessed to the crime when he turned himself in. Could he eventually plead guilty? What about a plea deal down the line? I'm sure these are all options.
Excuse me. Yeah, here's why. Because the death penalty is sought. And, that's the ultimate sanction. They say there's aggravating circumstances here. Specifically, it was so reckless he could have endangered others or did endanger others. So when you have the death penalty hanging over you, boy, and they come in with anything that might give you the possibility of parole even after a long, lengthy life, close to life sentence, that's something you consider when the evidence is real strong. I think both sides agree the prelim has to go forward. You have to get a preview of the evidence the trial would have, and then you start talking negotiation.
Mark, I have 30 seconds, but based on the publicly known evidence, how do you expect these hearings for the week to play out?
I think the defense may not challenge a lot, and it's going to go very smoothly for the prosecution, but it is going to dispel all these conspiracy stories that you hear about this, and it'll be just it's just going to be a standard set. This was, what you saw and what you believe happened.
Mark, I always enjoy our conversations. I really do appreciate your expertise. I'm sure we'll be talking soon about this very case. Thank you again.